Well, Mr. Eady, as it is the government that asked for this hearing, although the hospital also wants it, we think we'd better hear from you first.
I'm very grateful. I understand there's to be a minute's silence at 11.
11 o'clock, yes. It will be announced.
My lady, it's perhaps appropriate that I should make clear at the outset the basis on which the government is before you. The government has played, as you are aware, no part in the proceedings before the High Court, before the Court of Appeal, or indeed before the Supreme Court when you refused permission. The government played no part because the issues that arose were issues as to the best interests of this child, including the continuation of artificial ventilation and the possibility that the child might be moved to the United States for nucleoside therapy. And that was an issue, or a set of issues, that arose between the responsible clinicians and doctors at Great Ormond Street Hospital, the guardian protecting the interests of the child, and the parents. And Her Majesty's government had and has no role to play in the resolution, still less the determination, of those issues. That determination is properly, we submit, for the courts and not for the government. But the government is necessarily involved on the international plane in proceedings before the European Court of Human Rights. It is the respondent to any such proceedings. ECHR proceedings, as you're well aware, are not against those who have been party to the domestic proceedings, and in those proceedings it will be for the government to defend the actions of all concerned in this case within the UK. So it will defend both the state of domestic law and the decisions made by the courts, insofar as either raise issues about compatibility with the European Convention on Human Rights.
It's important that everybody should understand that the proceedings in Strasbourg are not an appeal from the decisions of the courts of this country.
My lady, quite so, and we understand that.
And Strasbourg has no power to change the outcome of legal proceedings in this country.
That is also true. But as you are aware, the European Court does have a process, yes, which brings us here, whereby it can request the government, as the party to the proceedings in Strasbourg, in summary, to maintain the status quo pending its consideration of the application before it, that is the European Court of Human Rights. That's the Rule 39 process. And just for those who are listening who are less familiar with that process, the Rule 39 process involves the European Court in Strasbourg requesting the government to maintain the status quo pending its determination of the complaint or application that is made before it. And my lady is entirely right. The court in Strasbourg has no power to enforce such a request against a sovereign government. However, if such a request is not complied with, there is a risk, and I emphasise that it's a risk, but there is
Lords, ladies and gentlemen, Her Majesty's government has asked that the nation observe a 1-minute silence at 11 o'clock today to remember those killed or otherwise affected by the Grenfell Tower fire. As the time is now approaching 11 o'clock, we ask all those in the building at this time to stop what they are doing and stand in a moment of remembrance and reflection. I will announce when the minute is over. It is now 11 o'clock. 1 minute has passed. Thank you for your mark of respect.
Thank you, Mr. Eadie.
My lady, I was saying that the court in Strasbourg has, of course, no power to enforce a request under Rule 39 against a sovereign government. But if a request such as that which has been made in this case is not complied with, there is a risk of finding the government liable for a violation of Article 34 of the Convention, which is the provision in the Convention which protects the effective right of individual petition. You will be aware that when the court sent the letter to the government, the Rule 39 letter, it referred to a Turkish case in which such a finding had been made. And the United Kingdom has, I think, on at least one occasion, I think in the El Sadoun case, also been found not to have complied with Article 34.
Mr. Eadie, I do not think that the court has been supplied with copies of any communications from Strasbourg.
Well, then we will make sure that you get those.
We have your note in response.
Well, I hope that summarises the position accurately and properly and fully so that you have all the relevant facts, but we'll make sure you have the correspondence.
It would help.
This court has now twice stayed the effect of the declarations made by Mr. Justice Francis. It has done so following its own refusal of permission to appeal. It did so on the first occasion for the purpose of enabling the parents who had indicated a wish to apply to Strasbourg to make an application for a Rule 39 measure or a Rule 39 request. So the first stay made by this court was for the short period to enable those matters to be considered by a chamber of the European Court. That was then prolonged in a second stay once it was indicated that the duty judge in Strasbourg had looked at the matter and wished the chamber to look at it. So it was extended for a short period of 2 or 3 days to enable that to happen over the weekend. And of course, the effect of such a stay by the domestic court is that it would not be lawful for as long as a domestic stay is in place under domestic law to cease artificial ventilation. That was the effect of the stay. However, as you're aware, on the 13th of June, in an email from the court, the
effect of the stay, Mr. Eadie, was that it would not be unlawful to continue it. It's not the same.
Well, as we understand it, Mr. Justice Francis had declared it to be lawful to cease artificial ventilation. And so the effect of the stay was at least to suspend, whether one casts it as lawful.
It would not be unlawful to continue it.
Yes. But just to complete the chronology, on the 13th of June, in an email from the court declined a request to continue the stay pending this sort of hearing, and appeared at least to suggest that it was for the government simply to indicate whether it intended to comply with the Rule 39 request. And the reason, in part, that you are here at our invitation is because that placed the government in a nigh-on impossible position. It was and is in no position to judge or to assess what is and is not in the best interests of the child. In ordinary circumstances, it would, of course, wish to seek to comply with Rule 39 requests, if possible, in faithful compliance with its obligations on the international plane. But this situation, and this case, it might be thought, is extraordinary at almost all levels, including at the human level. But there are very limited, if any, real practical steps that Her Majesty's government can take to protect the interests and to hold the ring. We cannot compel doctors to act in ways that they do not consider is appropriate.
Is it open to the government to reply to Strasbourg's invitation by pointing out that it has been held by Mr. Justice Francis and by the Court of Appeal that it is against the best interests of Charlie that he should not have the artificial ventilation withdrawn and should receive palliative care?
My Lord, it isn't impossible for the government to do that, but the government is very well aware that Strasbourg is very well aware of all of those facts, and they nevertheless made a Rule 39 indication.
Why do you say that Strasbourg is very well aware of that? I mean, has Strasbourg, for instance, been supplied with a copy of my lady's ruling?
Yes, they've been supplied with Mr. Justice Francis's judgment, the Court of Appeal judgment, my lady's ruling.
The papers with which we have been supplied by the parents' legal team are the Rule 39 application, which was dated before the hearing on the 8th of June, and did not, of course, therefore, have the ruling that we made.
My Lady, I rise hesitantly, but I should tell the court that your ladyship's ruling, the note taken and approved by your ladyship, was sent to Strasbourg. Indeed, they wanted that before they considered.
Well, it seems to me very unfortunate that we were not so informed.
Sorry, my Lady?
It seems to me very unfortunate that we were not so informed.
I said, well, anyway, that was sent to Strasbourg.
When was it sent? Do you know?
Sent before we got the Rule 39 order.
You can get the date for us, yes, when it was sent. Thank you.
And come back to my Lord Kerr's question. We can, of course, say that, and we can, of course, repeat that, and we can, of course, get to a place. It is entirely possible that we will get to a place where we have no option but to say something like that. Our concern is, and I hope it's...
Your point is that there is enough material before Strasbourg for them to recognise the dilemma that the government is placed in.
Yes.
If it agrees to the request that is being made, it's acting in the judgment of Mr. Justice Francis and the Court of Appeal, it's acting against the best interests of the child.
Well,
with respect, the government can't. The government cannot act contrary to the orders of the competent courts of this country. It never has been able to do so. And the proceedings before the competent courts of this country, apart from what we're now engaged in, are completed.
My Lady, I understand that entirely. The reason I am here is because the government would not wish, unless it has to answer a question implicitly but directly posed in the email that I referred to of the 13th of June from this court, to end up in a situation of conflict between the conclusions of its own courts and a serious request made in a serious spirit in a troubling case like this under Rule 39 by the European Court. And so we may ultimately end up in a position of the kind that my Lord puts to me, but I want to be absolutely sure before we go there that the view of our domestic courts, and I entirely agree with the point that my lady has just put, we cannot act against the views of the domestic courts, but I want to be entirely sure before I go and have that debate with Strasbourg about Rule 39, whether it should continue, whether we should take, what position we should take about it, until we are absolutely clear that the courts have reached the view that there is nothing more that they wish to do or can do, and so on. I'll give you an example of the nature of the concern.
Just before you do that,
yes.
You alluded in your note to the question of whether the government might invite Strasbourg to, well, this is a paraphrase, to rescind its invitation. Is there a procedure for that?
We can go back to Strasbourg, and there is nothing, I think, to preclude us from saying we have been back to our domestic courts, we've seen whether there are further issues that they want to think about, whether there are further things that they think could usefully be done or should usefully be done, and I'll come to those in 1 second. The answer to that question is no, please reconsider. There is nothing to preclude us from doing that, but you'll appreciate the position that we are in. When the Rule 39 order or request was made, the legal advisors for the parents wrote to the government on an asserted basis of confidentiality, which is a separate set of issues, but they wrote to the government and they suggested that the appropriate way to comply with the Rule 39 request was for the government to facilitate the transfer of the child to the US for the purpose of receiving nucleoside therapy. And they consider, it appears from their emails, they consider that there is no need for a further hearing before the domestic courts because the matter is simply for Her Majesty's government to comply with Rule 39. Now, just pause there for a moment. That situation, that position, we respectfully submit, is problematic in the extreme. It's problematic for at least 3 reasons. The government is in no position to judge whether any additional delay could be accommodated with the best interests of the child. Her Majesty's government's understanding, at least, is that transfer for that very purpose to the US was considered in detail and was ruled upon by Mr. Justice Francis and then in detail by the Court of Appeal, and their conclusion, if we've understood it correctly, was that it positively would not be in the best interests of the child for 2 particular reasons. Firstly, going on the Court of Appeal judgment, firstly because there was 0, or as close to 0 as makes no difference prospect of it achieving any benefit. And secondly, because of real concerns, irrespective of the arguments about the appropriate legal test, real concerns on the evidence that would involve, that transfer to the US would involve significant harm. You'll recall that debate about the tests on the facts anyway. And there is now no stay in place. But with respect, we don't see how we could possibly do, without the permission of our own domestic courts, that which the courts have concluded is not in the best interests of the child. And indeed, the impossibility of the position that we are put in is illustrated by the entirely proper position of the guardian of this child in the domestic litigation. Their primary position, if we've understood it correctly, is that there should be no hearing and no further consideration by the courts of what should be done now, because they have already finally ruled against the continuation of artificial ventilation and against precisely such transfer. So we have 2 different parties to this litigation advocating no further consideration by the domestic courts for diametrically opposed reasons. And that is a dispute, that is a set of issues which we cannot sensibly or properly constitutionally resolve. And the question that perhaps it might be thought lies at the heart of today's proceedings is whether there is anything further that the courts feel they can or should do. We know that this court considered it appropriate, at least on 2 occasions, to continue a stay, at least to facilitate the initial process of Rule 39. So there is a question to which the answer may well be no. We don't terribly care what the answer is as to whether or not this court wishes to continue any stay. But even if it doesn't, it might be thought, be a further question. And the further question, it might be thought, has not yet been finally answered by the courts. If you conclude that it has been finally been answered by the courts, well, so be it. And that question is whether the best interests of the child could consistently conform to a potentially short additional delay to enable Strasbourg to rule on any application that is made. Now, I just simply don't know whether you would feel that that is a question that has been finally disposed of. And as I say, I don't terribly mind what the answer to that question is. If the answer to that question is, your view is that it has been, then that is the end of the matter in the domestic proceedings, and I will go back to Strasbourg and have whatever arguments need to be had in Strasbourg on that basis, because we have to conform to what you finally say about the best interests of the child.
Speaking for myself, I'm sorry.
No.
Speaking for myself, I think it would be quite hard in view of the history of this case and the disposals in this case to say that it was in the interests of the child for there to be any further delay. Nevertheless, it may be a case where the interests of the child have to be balanced against the right of effective application for a very short further period of time, Mr. Eady.
My Lord, with respect, that is my second question, as it were. The first one being whether, I mean, it's linked, obviously, whether you wish to continue the stay. But there is That is the question. And I don't want to get into it being an apples and pears comparison, because on one view, you're entirely right. The best interests of the child are one thing, and the right of individual petition is another thing. And it is a balancing exercise rather than a conforming exercise, if I can put it that way. But that question, I'm not sure, has been asked. We know that the courts were prepared, and of course it was to protect their own internal appellate processes, with the agreement of the hospital acting responsibly as they have throughout this process. We know that the courts had been prepared, as it were, to strike that balance, or would have been prepared to strike that balance in favour of holding the position pending domestic appeal, and that also as a balancing exercise rather than a conforming one. The question is whether you are prepared to do so in order to allow Strasbourg, and it is different because it's on the international plane, as my lady pointed out earlier, whether you're prepared to do that to allow Strasbourg to rule.
The difficulty, Mr. Eady, is that Mr. Justice Francis made his declarations over 2 months ago, and there's been stay after stay after stay. So there has been order after order after order that something should be done, not in the best interests of the little boy.
My lord, I entirely accept that. And as I say, we don't take a position on any of this. Our position is, you tell us, and we will do whatever you tell us to do.
Well, when you say allow Strasbourg to decide within a short period, have we had any indication when a decision would be made?
Well, you won't be surprised to hear that we have been activating as hard as possible behind the scenes to get some clarity on that. Yes. The latest position, I think, is this. They have, Mr. Gordon has until midnight tonight to put in an application if so advised. You are all well aware of the, at least formal...
This is the substantive application.
Substantive application is midnight tonight. Yeah. You're well aware of the processes that in an ordinary case the court would follow in Strasbourg. They would consider, first of all, normally whether to communicate it to the government at all. They would then consider whether it was appropriate for a chamber or a grand chamber. If it stayed with the chamber, they would consider admissibility and possibly merits separately altogether. And of course, if the chamber does hold on to jurisdiction, there is the possibility of inviting the grand chamber thereafter. The indications from the European Court, if I've understood them correctly, are they have sought to make it clear that they are well alive to the urgency of this case, and they intend, as quickly as they possibly can do, to set a timetable for resolution of the case as soon as they get, and if they get, the application before midnight tonight. From our perspective, from the government's perspective, we have, as it were, already started work, you won't be surprised to hear, on observations that we might put in for the Strasbourg process. But I suspect that we will be suggesting that a period of about a week at the outside, if we can do it sooner, we'll do it sooner, but about a week for our observations. There may be a very short period then for reply observations, and then there will need to be a decision. And of course, if it's admissibility, and if it's done very quickly, you are talking, I think, probably at best and realistically, of a timetable that leads to, I'm just thinking of how quickly one might get to a final resolution. Inadmissible, if that's the outcome, that would be the first, as it were, possible final outcome in Strasbourg. If it's inadmissible, one might get there within a period of weeks. But it still leaves a delay, and we are very conscious of the point that my Lord Wilson put to me, which is that time and again things have been done and things have been held in that balancing exercise in a way that are not in accordance with the court's rulings in the best interests of the child. But I can't present and don't present anything other than our best estimate of what Strasbourg might do at this stage.
But what would be the basis of any decision that Strasbourg would make? Would it be that UK law, by saying that treatment of this aggressive artificial sort can only be given to a patient, whatever their age, an incapable patient, if it's in their best interests? Would Strasbourg be saying that that is a breach of the Convention rights Or would the government be saying that UK law is completely compatible with the Convention rights? I'm trying to get my head round any argument that...
Strasbourg.
Well, but also the impact on the law of this country.
Yes, yes.
It's not an appeal from us.
My lady, it isn't strictly an appeal from you, and of course there are proceedings on an international plane. But in answer to my lady's direct question, I've no idea how the application will be presented by Mr. Gordon, but I can tell you immediately and now what the government's position is going to be. The government's position, if all things stay as they are now, on the substance of the application, is going to be that the UK law, insofar as the challenge is structural, in focusing as it does on the best interests of the child, is entirely in conformity with the Convention rights and freedoms that exist, 2, 8, and or 5. That is the position structurally. We will also be submitting, you won't be surprised to hear, that all of the debate that appears to have occurred in the domestic courts, if I've understood it correctly, appear to be focused on the question whether or not one should start presumptively from a different place than a straightforward best interest place. In other words, by saying that if there was a viable set of alternative treatment and there would not be significant harm to the child, the parent's interest should hold sway. So that seemed to be the debate in principle before the domestic courts. Our submission is going to be that focusing, as the Court of Appeal did, and Mr. Justice Francis did, on the best interest is entirely in conformity with the structure and principles in the Convention in principle, but, and it's quite an important but in any event, the fact of the matter is that the Court of Appeal went on, if we've understood the judgment correctly, to reach very clear conclusions on the facts. And they concluded, in summary, that the outcome would have been the same whether or not Mr. Gordon's submissions on the principles to be applied, the presumptive approach to be applied, were correct. I put it that way because they made, if we've understood it correctly, 2 findings. One was that there was no viable alternative treatment for this poor child because the prospects of nucleoside therapy assisting in the treatment were as close to zero as made no difference. And secondly, not an issue considered by Mr. Justice Francis, but that's because the argument of principle was run differently before him. But secondly, and in any event, because there would be significant harm to the child in the prolongation of life in the way necessary for that therapy to be provided in the United States. And if that is right, we have 2 strings to our bow in Strasbourg. Our law is compatible structurally, and secondly, on the facts, irrespective of whether it's a pure best interest child or something weighted rather more in favour of the parents, makes no difference because of the findings of fact that the domestic courts made and were entitled to make. And my lady will be well aware that Strasbourg is reluctant, to put it mildly, properly reluctant, as a court of quatrième instance, or it's not a court of quatrième instance, it's reluctant to interfere with findings properly made by domestic courts after receiving evidence. So that's what we will be saying in Strasbourg.
Well, it would undoubtedly be the case that when considering the best interests of any person, the continuation of life
is an important
presumptively in their best interest.
Of course. And it's self-evident also that the wishes of parents in a tragic case like this, are also thoroughly important. But again, there is no punch to that argument of principle if the domestic courts treated the wishes of the parents as a thoroughly important factors, as they self-evidently did. They said so in terms. So, my lady, that's what we'll be saying in Strasbourg. But as I say, I emphasise again, because I know there is real sensitivity for those who are primarily instructing me, to make it absolutely clear, and I know the court understands this, that we take no position on the best interests of the child and all of those issues. They're simply not properly for us. We will go back to Strasbourg with whatever you tell us to go back to Strasbourg with. But we're here to say to you, have you reached the end of the line? If you have, we'll go back on that basis. If you haven't, then it's for you, with the assistance of others, to work out what else there is to be done.
Well, there are different lines, are there not? As far as the substance of the matter, the applications that were made before the High Court, the appeals to the Court of Appeal and the application for permission to appeal to this court, that is the substantive end of the line. There could be no further application unless there were admissible, fresh, powerfully persuasive evidence to counteract the finding that what is proposed to be done is so unlikely to succeed as to be futile. There could be no reopening of these proceedings, and they have reached the end of the day. So that's one thing. But the other thing is this court has assumed jurisdiction to grant a stay of those orders, which it could certainly have done before it determined the permission to appeal application, so we had it in mind at the time.
Yes.
And so the question is whether we could continue the stay of the declarations. And that is the matter with which we're principally wrestling at this moment, because of the very extended timetable that, frankly, we're contemplating. We cannot.
Yes, I mean, one halfway house. I mean, my lady, I'm sure you need no assistance from me about those options. The only other thing, I suppose, to pitch in is whether or not the best interests of the child have been analysed in quite the way that now arises. I mean, it's a bit like protecting the matter pending an appeal, although it isn't quite like that, because it's domestic appeals that you've been protecting it from up till now. But the question is, I deliberately put it on the basis of whether the best interests of the child could consistently be held pending the Strasbourg resolution. And it, of course, on one view, that's a question of stay for you, but there is at least a question within that as to whether or not it has an evidential flavour, at least, because it may raise questions about the additional harm that or if there is any, that the child might suffer by prolonging the period.
Well, we'll have to listen to the hospital.
We'll have to listen to others in relation to that. But other than that, my lady, I respectfully agree that that's the difficulty. As I say, one possibility may be to approach it on the basis that you don't have to grant a stay forever now, if that's the course that you do choose to go down. I mean, it may be one thing to say we are prepared to hold the ring for a period of 3 weeks, say, but we are not prepared to extend any stay beyond that period. I mean, it isn't necessarily an all or nothing, particularly with the state of process and the timetable in Strasbourg as fluid as, unfortunately, despite best endeavours from all sides, it evidently is at the moment. I'm not sure there's much more I can add to assist.
Well, you're in a very...
Made your problem more difficult rather than easier, but I hope at least you understand why we're here.
It's never been an easy problem.
No.
We've known that from the moment that this case came before us. And we understand the difficulties that the government was placed in.
And I'm grateful.
So thank you, Mr. Eadie.
I don't know who's going next.
Well, I think Miss Gollop would probably better go next.
There is not a great deal that I can say in addition to the email that I understand has very kindly been put in front of you, which I drafted with some care and at some length. I know you'll have read that recently and have it in mind.
Yes, this is your email of the 16th,
Yes.
Friday, yes. You said you would welcome a hearing.
And we are very grateful. I attended the directions hearing in front of Mr. Justice Francis back in March. And on that occasion, I said to him that the hospital's view then was that every day that passed was a day that was not in Charlie's best interest. And the hospital had reached that view after very careful deliberation. And you may recall that what had happened was that before Christmas, the hospital had been entertaining the possibility of providing the nucleoside treatment at Great Ormond Street, and was on the verge of putting that treatment, which, as you will also recall, has never been tried on a living creature with this condition, particular variant of it, before the Ethics Committee, because Ethics Committee approval would be required before the treatment could be administered. And then that Ethics Committee approval was, in the event, never sought because of a deterioration in Charlie's condition that occurred in around December, January, when it was considered that he had suffered irreversible brain damage, and that any opportunity that there might have been for treatment to have any chance of providing any amelioration of his condition had now gone. And that, as I say, was a decision that the hospital reached in January. And then the process takes its time, and the doctors understand that. And on every occasion that a stay is being granted, I have explained to them that the process takes time, and they have very properly taken the position that we have a jurisdiction. It is entirely right and proper that where there is an irresolvable dispute about what should be done for a child between the doctors and the patient, the parents, that exists in good faith, the courts should be asked to resolve it, and the court process takes time, and the hospital should continue to treat while that process is pursued, and very properly, as is their perfect right, the parents have sought to obtain a different outcome for their child. But we are now at the stage, as you have indicated this morning, where that line has come to an end, and it will not and could not ever be open to Strasbourg to reach a different determination for Charlie. Against that background, he continues to be kept in the parlous condition that was described by all of those who have seen him and is set out in his decision by Mr. Justice Francis. And he must continue to suffer that day after day, whilst it appears a new court process commences. And this is the end of the line so far as the doctor's understanding of what they can reasonably be expected to do for the child is concerned. That isn't to say that they will not abide by anything that you say. None of them have, and I have asked the question repeatedly, said to me, in conscience, we can no longer do this, but they are at the limit of what they can understand in terms of their duty, which is to put Charlie first. And it was against that background that I said the hospital would welcome a hearing. And we are grateful for your time today. I don't think there's very much more that I can say. I would only say that if it were finally your view that you wish to make an order that said that it would not be unlawful for a further period of life-sustaining treatment to be provided, I think the hospital's preference would be for that not to be open-ended, but for it to be periodic, for reasons that will be obvious.
There's a further point in the penultimate paragraph of your email. if the court's decision is that treatment should continue indefinitely or for a lengthy defined period of time, the hospital would be much assisted by clarity as to what interventions are and are not in Charlie's best interest and what lawfully they can and cannot do. Is there anything you want to say in expansion of that?
Yes, I had asked whether there could be a list provided to me of interventions that could be foreseeably required in the event of a deterioration. And at one point I had such a list, and then the doctor said that in fact they didn't want to put before you a list because the doctors were, and all of those treating for Charlie were of the unanimous view that there was nothing that was in his best interest. Other than the palliative care that Mr. Justice Francis declared was in his best interest in April. But the interventions that could be foreseeably required would be, for example, antibiotics in the event of an infection, cardiac pulmonary massage or resuscitation in the event of a heart attack. Those, I think, were largely... I will turn my back, if I may, for one moment and ask the medical director. Perhaps importantly, the only other thing would be if his the tube that allows him to be ventilated were for any reason to become disconnected or to come out, whether that should be recited.
No way. He's got a tube that's meant for a premature baby in him. He's had it in since January. There's a breeding ground bacteria. He has not had one infection. No way. It is so short.
Mr. Gordon, would you be kind enough to ask your client to... I'm sorry, we have to have...
I think it's very difficult to be prescriptive because obviously these decisions have to be taken in reaction to the situation that the doctors are confronted with.
My Lord, I entirely agree it is. The doctors are in an invidious position and it may be one that the courts can't assist them with. It will not surprise you to hear that at various points along the road, letters have been written by the parents' representatives saying that if life-sustaining treatment is not continued, then the parents will consider a complaint to the Crown Prosecution Service. They are operating against a background of being potentially liable to a criminal assault if they continue to treat, and potentially being liable to prosecution for murder and manslaughter. If they provide palliative care only, they may be open to criticism at any inquest that there is, and they want to make sure that at all times they comply with the GMC's guidance, which is to put their patient first. So it's against that background that I wrote the penultimate paragraph. I'm very well aware of the impossible, almost, position that you're in, and you're aware of the impossible position that my clients are in.
Yes.
As would be any set of doctors who were required to care for Charlie, which, as you may imagine, doesn't mean that the room is jumping with hands in the air.
No.
Ms. Golub, if some development of that sort occurred, would a telephone application to the out-of-hours family division judge not be an immediate way of obtaining a ruling?
It would if it was something like an infection. If it was something like a heart attack or a tube coming out, it would not, because time would not permit.
Thank you.
Thank you.
Thank you, Ms. Gollop. I think, Ms. Buttle-Cole, it's probably for the Guardian to come next.
Yes, Lady Wilkes. The Guardian's position is that there are no further evidential best interest questions to be considered. The court's already indicated that the domestic pleadings have reached the end of the line, but in our version that applies equally to this possible new question that's been floated as to whether there might be some different best interest analysis to be conducted in light of the timetable that the European Court is able to set down. In our submission, the only proper way to look at that is in relation to the question of a stay, not as a further best interest question. And in deciding whether a stay should be granted, it's fairly clear that actually the best interests of the child haven't prevailed to date, and the Guardian has accepted that as the domestic proceedings were continuing, despite Miss Justice Francis's findings, it was appropriate for those stays to be granted in order that those proceedings could run their course, which they have now done. And again, if now we were faced with the possibility of a short further adjournment or a stay pending a final decision, then perhaps once again the Guardian would say it's not strictly speaking in the child's best interest, but we can see the reasons for permitting the stay. Unfortunately, it seems to the Guardian that we're not in that position. If the best case scenario is a final determination by Strasbourg within 3 weeks of today, that's one thing, but one has to take into account also all the other possible scenarios that are not that, and that's the granting of permission to proceed, the decision that the case is admissible, then the further hearings and so on and so forth. And so it seems to the Guardian that focusing purely on the best interests of Charlie, further stays, even broken down into short periods, which will then inevitably be followed by another application for a further extension while the court process takes its next steps, aren't in Charlie's best interests. And so while we understand and can see why the court might wish to grant a further stay for a short period for the next stage of the process to take place, it's not something which the Guardian can support on Charlie's behalf.
Thank you very much, Ms. Butler-Kell. Mr. Gordon. I know you didn't want this hearing, Mr. Gordon, but you're here and we would like to hear from you.
I need to be very polite about the hearing, my lady, but may I just make the point that there is a very short time to go before we can put our application in. Mr. Eady said midnight. We don't think it is midnight. We think we will have to lodge it before the registry closes at 4, and of course it's the differential timescale with Europe. So I've still got to oversee the preparation of that appeal. Can I make an obvious point? This is an incredibly stressful case, not only for the parents, not only for the clinicians, but I venture to say for all the legal representatives presenting it. Can I say, first of all, that the stay that this court granted on the 8th of June was for the specific and express purpose of allowing the parents to seek a Rule 39 determination. They have got that determination, and to that extent, they have succeeded. And so the logic of the grant of the original stay would appear to suggest that having got the Rule 39 indication, the parents should be given the opportunity, as I'm talking at the moment only about very limited domestic law, should be given the opportunity of Strasbourg determining their substantive application. Now, there are all sorts of practical issues about time, and my Lord Wilson has adverted to those. There are also quite serious constitutional questions about the court's role. It's a rather strange role in some ways, because as advocates, and Mr. Eady will include himself in this, we are, of course, in a way bound by what the court says, by its rulings. But on the international level, the court, in one sense, is, of course, an entity, a body, for which the government is responsible. And so
it's a public authority.
Yes.
Under the...
So the constitutional question, really, which I am not equipped to argue today, but the constitutional question is, what is the role of the court in this, I venture to suggest, unique situation? Where I've come to, in terms of analysing, is that the court can play a facilitative role. That is to say, a role which enables the Rule 39 indication to be complied with. I would like to argue, but haven't yet got the materials to argue it, that even as a matter of domestic law, this court should do all in its power to comply with the Strasbourg ruling. I say that really for two reasons. First of all, because as a matter of elementary common law, predating the Human Rights Act, a court will do all in its power to comply with international treaty obligations. Secondly, and less confidently, but nonetheless arguably in my submission, Article 13 the right to an effective remedy, which is not expressly contained, not referred to in the Human Rights Act, may itself be thought to be intrinsic to all the convention rights that are protected in Schedule 1, because each and every convention right has its own procedural protection. In other words, to ensure that Artico in Italy, human rights are effective, practical and effective. And so there is an argument, and the former Lord Chancellor, Lord Irvine, adverted to it when introducing the Human Rights Act, that Article 13 was implicit in the whole of the statute. Now, these are big arguments, and I certainly don't want to put these forward today. May I suggest that the sensible way forward is, I think Ms. Gollop used the word, I think possibly Ms. Butler-Cole used the word periodic, to grant a short stay consistent with your original stay, to allow for, shall we say, a short and abbreviated timescale in Strasbourg, and to monitor the situation carefully after that. I would certainly wish to have the opportunity of advancing the constitutional arguments that I have merely flagged up. They are very important arguments, because we would be saying that an order of the court that truncated and went against the original stay would itself constitute a violation of the convention for which the government was responsible. Now, I can't make that point today with any clarity, but I do want to make it now. The practical answer to this case in our submission, and it would follow the logic of all the stays that have so far been made, I accept for over a protracted period. The logic of the situation would be to make a short order for stay now, picking up the words of the press release, putting, as it were, the present situation in proper order in domestic law. And my suggestion would be to stay for at least 3 weeks. In fact, realistically, I would suggest a month, picking up everything that Mr. Eadie has said with his customary integrity and expertise, and then review the situation if it has to be reviewed. But we fully understand the tension that the court's under, that the government's under, and that the clinicians are under. But this is a case where the logic of our application to Strasbourg is that currently the law, if it allows state intrusion on this level, to this extent, allows a patient in a hospital to be kept, confined outside its parents' will, is not convention compatible.
His parents' will, not
Parents,
its.
I'm sorry,
Charlie is not it.
My lady, I read your Dublin lecture, and I do apologise. I understand that. His, absolutely. But that's the reality here. Can I just answer a question?
Could I ask you something first, Mr.
Yes, of
Gordon?
course.
What was our jurisdiction to make the order that we did on the 8th of June, having refused permission to appeal?
The jurisdiction was the jurisdiction that arises as a domestic court doing all in its power under common law to facilitate a request from Strasbourg. Pre the request, to give us the opportunity, consistent with international obligations, of seeking that ruling.
As we were strictly functus officio. Now, we could have done it beforehand, and maybe we can rationalise it by saying that we would have done it beforehand.
Yes.
Had that been what we were asked to do. And that may be the answer to it. But
I would go further. I'd certainly say that, my lady.
this court has no common law jurisdiction.
Well, we are in...
Has whatever jurisdiction the House of Lords.
We are in convention territory, and as your ladyship says, there is a degree of flexibility in the scope of the Supreme Court's powers. But certainly, in the context of convention law, the court is a public authority. It has as much an obligation as a subordinate entity of the state to observe the convention rights. And if we're right in our argument, and so far Strasbourg will need to consider the merits of that, but if we are correct, we would be deprived of an effective remedy under the convention by the making of any order which effectively aborted the possibility of our seeking Strasbourg's ruling. So that's what we say about that.
When you say we, let's get this completely straight. You are acting for Charlie's parents. Quite right so, quite rightly so. So the application that you make to Strasbourg is on the parents' behalf.
No, there's an application for the child and the parents.
But the parents are not, for the purposes of these proceedings, representing Charlie.
My lady,
That's a point that Strasbourg is going to have to think about.
they will have to think about it. But may I just make one very elementary point here without going back into the argument? Because again and again and again, it is said that Charlie's best interests are as found by the court. Now, the parents, I hope this court would accept, would not willingly act against what they perceive to be Charlie's best interests. And as I articulated on the last occasion we were here on the 8th of June, the question of principle, and it's a convention question, is who decides the best interests. And I think I reminded this court of what, in argument...
Well, we know what your arguments
I don't want to go back.
We heard them,
We go back
and
in.
so we do know what they were. But I did want to make it plain that, obviously, Article 8 is one set of rights. Article 2 is another set of rights.
And Article 5 is another.
Yes, but let us concentrate on the two major ones. Yes. The Article 2 rights are Charlie's rights.
Primarily Charlie's rights. There are some...
Yes.
Your ladyship will know the law on this. I really don't want to get into making detailed submissions to the court at this stage. I'm not prepared. When I say I'm not prepared, I'm prepared to do so, but I'm not prepared. I haven't had the time to prepare. Very short notice was given to this hearing for reasons I fully understand. But just in with my Lord Wilson's question, we gave notice to Strasbourg of this court's ruling the same day, the 8th of June at 7:44. So that was...
And sent the transcript.
We sent the transcript, yes. We sent the note that was approved by this court of,
yes.
of the ruling.
Yes.
That went to Strasbourg.
Thank you. On the same day.
Yes. Strasbourg has had everything. And that's the point that my learned friend Mr. Eady candidly makes. They've had everything material, and obviously it's within the UK government's power to write to Strasbourg, to seek to make representations to Strasbourg. All I'm concerned about in this hearing is to avoid our remedy being aborted. And actually, we would respectfully submit this court taking an action which we would have to contend brings the court at risk, to use Mr. Eady's words, of an Article 34 violation against the government.
Mr. Gordon, so far as the communications of your solicitors with Strasbourg are concerned,
yes,
I did collect from reading the emails that there'd been some hiccup about giving copies of what you were saying to Strasbourg to the government, Great Ormond Street, the Guardian.
yes.
We won't go over past ground,
No.
but can we have your assurance that anything that is sent to Strasbourg, including obviously this afternoon's application, but everything else is timeously copied to the government, the respondent to it, to Great Ormond Street, and to the Guardian?
My Lord, I hope you'll forgive me if I just take very brief instructions.
Thank you very much.
Well, I'm not getting clear instructions on this, or the clearest. My solicitor is particularly concerned as to whether there might be a breach of confidentiality in serving non-parties. That's what's just been put to me. But can I just, by the way, indicate why we served the government but not GOSH? As I understand it, the Strasbourg rules make no provision for service at this stage. But the government asked for the papers, and because the government was going to be a party to the case, we agreed to serve the government, and we did so. The reason for not serving gauche is twofold. First of all, because it isn't a party, and secondly, because the Strasbourg rules do not appear to contemplate it. Now, certainly, I would agree that if the Strasbourg court wants the gauche to see the papers, we would obviously have no objection.
I think we're talking about whether the UK Supreme Court wants it.
My Lord, I understand what your Lordship said, and I've put that to those instructing me. I'm more than happy to repeat your Lordship's request, but your Lordship will see the position I am in, trying to reflect my instructions by way of submission. So I'm very happy to put your Lordship's point again.
Well, I don't think there's any point in putting it again. We'll have to decide what to do about that, Mr. Gordon. I'm absolutely taken aback.
I would like to put it again, given your Lordship's clarity in terms of what your Lordship's just said. But I hope the court understands my position. I can only act on the instructions I have.
Taking instructions, it might be thought it's a particularly pertinent question, given the fact, as we understand it, that Charlie is included as an applicant in the Strasbourg proceedings. So if the guardians do not see the basis on which that is made, there's a particular problem.
My Lord, I have told those instructing me that they should comply with the Supreme Court's request. I'm told it's been left to me. So if it's left to me, that's what I say to the court.
Thank you.
Thank you, Mr. Gordon.
Thank you.
Mr. Eady, is there anything you'd like to come back on?
Thank you, unless I can assist further.
Well, thank you very much indeed. We will now retire. We may or may not. What we contemplate doing is giving a written ruling, either later on today or tomorrow, but preferably later on today. That is what we contemplate doing. And it's probably sensible for us to do that rather than keep you all waiting while we work out the terms of what our ruling are going to be. I think that would be the best thing to do. So
we're retiring fully now.
We're retiring fully now.
We're finishing the hearing.
Yes, we are. Yes. Thank you all very much indeed. I think it was important to bring this case back in the light of what has transpired, and we will try and resolve whatever it is within this court's power to do as soon as possible.